Counsel, I'm sorry, I'm going to interrupt you already. I don't think there's necessarily any reason you would be naming kids or anything, but we don't.
To be what, Your Honor?
We don't name kids, children, minors, okay. And we just refer to them as daughter or son or by initial or something. And then please stay behind the podium because I keep forgetting that we're getting recorded, so.
Okay,
thank you.
not a problem. And there are no children involved in this particular issue.
I couldn't remember, so that sounds good. Thanks.
Tangentially. Good morning, Your Honors. May it please the Court, Michael Connick on behalf of the appellant Paul Simon. As the history of this case reflects, this is the fourth time, or the fourth trip, that these parties have made to this court in the over 10 years that the domestic relations case has been pending pre- and post-decree. The procedural history is fairly clear as to what occurred and why we're here. This is an instance where conduct on the part of the trial court is inexplicable. We were dealing with a pro se individual who had succumbed to the financial stress of not being able to hire an attorney, while wife had, or appellee, had multiple attorneys. Mr. Lane and I are the most recent iteration of counsel in this case. This case started with Judge Quinn. For reasons unknown, he took himself off the case and gave the case to Judge Hayes. In July of 2016, Judge Hayes wanted off the case, made a statement on the record that he wanted an entry so that he could recuse himself and be done with this. Well, he wasn't quite done. Several months later, after directing the parties to submit arguments, which was done by both parties, counsel for appellee, unsolicited, without court order, without any direction from the court whatsoever, filed findings of fact and conclusions of law, which the trial court then, Judge Hayes took, and he made a couple of modest changes, but he adopted appellee's counsel's position in its entirety. And if we look at the record in this case, at the July 19th, 2016 hearing, the judge went on the record very briefly. There were no witnesses who testified. There were no exhibits submitted or even discussed. There was nothing put into the record from which someone could draft a set of findings of fact and conclusions of law, for the very simple reason that there were no findings, there were no facts to find.
Well, counsel, assuming all that is correct, how are we properly here? Why wouldn't that have been appealed?
Well, part of the reason is the appellant was pro se, and there was an error that resulted from that. And it could have been appealed, possibly should have been. I can't honestly, truthfully tell you that it's even a final appealable order. There are still matters pending before the trial court. Judge Quinn, after Judge Hayes' adoption of the findings of fact and conclusions of law, denied the motion to vacate pursuant to 260B. After that, he took himself off the case again. And Judge Hoffman out of Stark County is now the visiting judge that has set aside, or choice of words, has essentially stayed the remaining proceedings between the parties so that this court can make its determination in this case before Judge Hoffman takes any further action. And that was a decision that was made by Judge Hoffman in a pretrial conference after the briefing had commenced, but had not yet been concluded. There are multiple issues remaining. The irony in the adoption of the findings of fact and conclusions of law is that in one of the prior iterations in front of this court affirmed the trial court's decision to take all the children's matters and send them to the state of Kentucky, the Commonwealth of Kentucky. And the court essentially divested itself of any jurisdiction relative to the children's issues. Yet, the order that we're here on, the order that was, the adoption of the findings of fact and conclusions of law, gives appellee a substantial sum of money, I think it was $10,000, for expenses for visiting with the children. That...
Counsel, I'm going to interrupt you again, I apologize. But when you say the matter that we're here on, the entry that we're here on, we're not really here on that entry, are we? We're here on the 60B.
That's correct. I misspoke.
No, I don't mean that. I just mean because that's why...
But the 60B is...
I need to know I said it wrong, and.
Well, the
and,
trial, okay,
and-
I didn't know.
No, that's okay, we're both talking, that's all right. Go ahead, you know what I'm gonna ask you.
Sure. The trial court in this instance rubber stamped Judge Hayes' adoption of findings of fact and conclusions of law. It gave no consideration to the elements set forth in Rule 60B, 1 through 5. There was no opportunity to present any evidence, it was denied without a hearing. And I think in this particular instance, where counsel for appellate, I say prior counsel, this is nothing this gentleman had anything to do with, unilaterally submits to the court a finding of fact and conclusions of law, which was his dictation of how the case should be resolved, what should benefit his client, what expenses, costs, division of property that Mr. Simon should be caused to bear. Didn't look at any of it. He merely denied the motion. There is a common opinion among our clients that they don't get treated fairly in court, and they particularly don't get treated fairly in domestic relations court. And when we have a judge adopt another counsel's findings of fact and conclusions of law, the next person to review that needs to take action, and Judge Quinn didn't. Not only did he not take action, he washed his hands of the case for the second time.
But that wasn't the standard. That wasn't what was before Judge Quinn to review the findings of fact and conclusions of law.
No, what was
He had a
before Judge,
motion to vacate.
yeah, that was what was before Judge Quinn, but it was founded upon the adoption of the finding of fact and conclusion of law. And did I reserve 5 minutes for rebuttal?
You didn't, but I figured you would like that.
Okay. So that's kind of the, when a court looks at a 60B motion, and we all know that these are looked at very stringently because litigation has to come to an end. We understand that. The catch-all provision, 5, has been referred to in case law as being there to correct the errors and omissions of a court. Now, when the people on this side of the bench make mistakes, it's called professional negligence. When the trial court makes an error of this level, it's referred to as an error and omission. There were errors, there were omissions. There was probably a distaste for this particular case in the court, since it had already been up and down 3 times. Now it's back again, and we have more issues, we'll probably be back again. But there needs to be a correction to what happened in this particular case. The mechanism, the vehicle that was available to the appellant was the 60B. That was offered to the court after he had the money to hire an attorney and to do whatever damage control could be done at that point in time and get the matter back before the trial court. The matter was before the trial court. The trial court, the record is silent, frankly, as to whether the trial court looked at anything in the record relative to what had transpired, including but not limited to the findings of fact and conclusions of law. He didn't do anything. He just denied the motion. I think under these circumstances, where I'm confident Mr. Lane will get up and explain to the court why we are trying to circumvent an appeal. In this instance, the catch-all provision of Rule 60B-5 is the one that is there to correct manifest injustice. Whether the appellant coulda, woulda, shoulda filed an appeal to the order that Judge Hayes put on, we all know the answer to that question. The fact of the matter is he was pro se. And while this court holds pro se litigants to the same standard as attorneys, this is a complicated set of circumstances. It's not merely filing an appeal. It's a directive from a court to submit argument, then an interloping set of finding of fact and conclusions of law without hearing any response from the appellant, to adopting those, to then being rubber stamped by the judge who had already stepped down from the case, and because Judge Hayes had recused himself, put himself back on. And immediately after he signed that entry, he recused himself again. The justice cannot be overcome in this instance. There's no way that a trained attorney or even a layman on the street is expecting to get fair treatment in our court system. We can't let this one go. There needs to be some recourse. And 60B5, I've been doing this a long time. I can't honestly tell you that I've ever seen it granted. Thank you. And on that hand gesture, I will sit down now and ask that the court reverse this matter and give Mr. Simon the opportunity that he deserved in 2016. Thank you, Your Honor.
Counsel, you have your 15 minutes.
Thank you, Your Honor. May it please the court, Attorney General here on behalf of the appellee, Malinda Simon. As you've heard, I'm sure as you've read in the briefs, this is a rather tortuous history of these folks, both in the trial court and in the appellate court. One of the unfortunate aspects of this case, along with many other cases that we've seen in our career, is that some of these cases drag on seemingly endlessly. And appeals and motions to vacate and motions to modify seem to provide for these parties an endless stream of not just litigation, but lack of result. And that is really at the heart of what this appeal is about and what this case has become about, unfortunately, is truly a lack of result, a lack of an outcome. My client, Malinda Simon, has been waiting for an outcome, for a result, for an answer for years. The hearing today is just the latest in a very, very long string of hearings that have resulted in, for her, no outcome. Particularly, we're here for a 60B motion on a judgment entry that was entered in April of 2017. That judgment entry modified prior orders from the court, granted motions to modify that had been pending for, at that time, more than 2 years, and modified, or I should say, addressed the issue of a pension that was not disclosed during the actual divorce proceeding. My client did everything she was supposed to do. She filed everything she was supposed to do. She followed the court's directives. Neither she nor her attorney did anything wrong. There's absolutely nothing improper about submitting to the court proposed findings of fact and conclusions of law, whether or not they're asked for. There's absolutely nothing improper about that. And if the judge decided to adopt some of those proposed findings of fact, he certainly is entitled to do that. We'll get to some of those specifics in a moment. But at the end of the day, Malinda Simon nor her counsel did anything wrong. In fact, she did everything she was supposed to do. She filed everything she was supposed to. The trial court issued an order on April of 2017, which modified spousal support and addressed one specific issue in regards to division of property. My client waited several months until September of 2017, when there was no follow-up from Mr. Simon, no payment of support, no appeal filed, no result, no conclusion, because he could continue to violate court orders. She did what she was supposed to do, which was she filed a show cause motion.
Counsel, can I go back to
Sure.
one of your last statements?
Yes.
And certainly I understand there's nothing wrong with filing findings of fact and conclusions of law, or for the judge adopting, or some or part or none, but does the judge have to have a record upon which to base those adoptions? And was there something here? I remember reading in the brief about attachments, something too.
Sure. So this was there's definitely an unusual proceeding the way this went forward, and this is a very unusual case. The reality is this is a difficult case, a very unusual case. So what happened when the parties were in front of the court back in, specifically on July 19th, 2016, They were there for a hearing on multiple motions. I think my client had something like 5 or 6 motions pending. Mr. Simon had multiple motions pending at that time. The court, the judge, told the parties that they could submit all the motions on argument if they chose to do so, which they did. At that point, Mr. Simon did not at any point object. He did not at any point say, I want to present evidence, I want to call witnesses, I have documents I need to put into evidence. It's telling that he didn't file a witness list or an exhibit list prior to that hearing, which is required by local rule. He didn't have any witnesses sitting there. He didn't tell the court, I have witnesses waiting to testify. He didn't object at all to the court saying, I want to hear this on arguments and submission of briefs. He agreed to it. In fact, what he did during that hearing was he apologized to the court for the fact that he had mishandled the issue of the pension. So what I would respond to your question, Your Honor, is I think the court, because the parties agreed that they were submitting this on arguments and briefs, had a record upon which to make those findings of fact. And the parties, by agreement, by not asking to submit any evidence, and by not asking to put any witnesses on, agreed with the court's suggestion, which is entirely proper. The court is not required in every instance, if the parties agree, to hold an evidentiary hearing. And we don't have juries in domestic relations courts. It's not at all uncommon for courts to hear submission of arguments as all the evidence they're going to hear, if the parties agree to it. And that's what happened here.
But back to Judge Callahan's question, did the parties agree where there's stipulated facts?
The parties agreed to submit everything on briefs and arguments. And they submitted, the court asked the parties to, by a specific date, I think it was September, I believe is what he had indicated, that he wanted arguments submitted to the court in writing, briefs, whatever you want to call it. And my understanding is both parties did submit briefs. And my client, through counsel, submitted proposed findings of fact as well. And it's I think, important that Mr. Simon did not object at all, even though he was given notice of the proposed findings of fact, given a copy of the proposed findings of fact, did not object at all to the submission of those at the trial court level. He did not, he had, I believe, 4 months before the judgment entry was eventually issued in April of 2017. I believe the proposed findings of fact were submitted in November of 16. He had 4 months to file an objection. He didn't. And the case law is very clear. You can't bring up an issue on appeal that you never objected to on the trial court level. Not only did that not happen here, there was no objection at the trial court level, there was no appeal filed of that. And I think we've touched on that already. The reality is, all these issues that are being raised before the court by the appellant in this hearing, or excuse me, in this appeal, are all issues that should have been addressed immediately after the April 2017 judgment entry was issued on direct appeal. It was a final appealable order. Very clearly it was a final appealable order.
That's what I was just going to ask you about.
Very clearly it's a final.
There wasn't another appeal pending at the time?
No, this was a final appealable order. This was an order that modified spousal support and issued a slightly different division of property. It's very clearly a final appealable order. And it's instructive, I think, that appellant doesn't make any argument in his brief that this was not a final appealable order.
Well, I think he does, though. I think he said there was an appeal pending at the same time.
There wasn't an appeal pending there was no appeal pending. He may claim that, but there was no appeal pending that took away jurisdiction of the trial court at that time. All the appeals had been finalized at that point. My client had 3 motions to modify pending with the trial court. There was nothing that took away jurisdiction from the trial court at the time when this was submitted, and certainly at the time when this April 2017 judgment entry was issued. So the court had jurisdiction to do this. It was a final appealable order. He could have filed an appeal. He did not. A Civil Rule 60 motion is not a substitute for an appeal, which is what is happening here. There are 3 aspects to, or 3 portions of a Civil Rule 60B motion that must be met. It has to be timely, there has to be a meritorious claim, and there has to be one of the Civil Rule 60B 1 to 5 has to be met. The only one that would possibly apply here would be Civil Rule 1, or excuse me, Civil Rule 60B1 of mistake. And that, so the case law is very clear. Civil Rule 60B1 for mistake is referring to a mutual mistake of the parties. It's not a mistake of the trial court, which is what appellant has argued in his brief. That's not what case law says, and that's not the intention of the rule. The intention of a 60B1 mistake order would be to correct a mutual mistake of the parties. That did not happen here. What happened here was the court looked at the arguments of the parties, looked at the submissions of the parties, and agreed with wife's arguments, and ruled against husband. And husband is now, 7 months later, decided he wants to challenge that, and that only happened after wife tried to enforce the order. So if there's any gamesmanship being played here, it's in regards to husband's decision to wait 7 months to do anything about this until wife actually tried to enforce this order. I think it's very clear that this is not a proper 60B motion. What this is someone trying to substitute a 60B motion for an appeal that should have been filed. I think counsel basically admitted in his argument that an appeal should have been filed, that an error was made, even though it's pro se, he's held to the same standard as attorneys are held. Ultimately, client, and my client in particular in this case, is entitled to a conclusion. She is entitled to a result. She's been waiting years and years. And by filing this 60B motion, what husband has effectively done is delayed a conclusion on these motions for another year, more than a year. This order was issued in April of 2017. There is still no outcome as we sit here in October of 2018 because of this Civil Rule 60B motion. It's not proper. The trial court, properly denied this Civil Rule B60 motion. It's not timely. There is no merit to any of the claims, and there is no basis under 60B1 or 60B5 to vacate this order. I'd ask the court to approve what the trial court did in this matter and deny this appeal. Thank you.
Thank you, counsel. You have 5 minutes.
I will be brief, Your Honor. Unusual proceeding, to quote my colleague. Sure is. It's the exact kind of proceeding that Civil Rule 65 contemplates. That rule, as it has been interpreted by the Ohio Supreme Court, is only used in extraordinary and unusual cases when the interests of justice necessitates it. Caruso-Cerisian versus Moment, and further approved by State versus Exwell, Gurisic versus Angelata. Catch-all provision is appropriate to be applied in vacating a judgment as a result of errors and omissions by the court. Judge Hayes entered into errors and omissions. He committed them. Despite what counsel would like the court to believe, the simple fact of the matter is there was nothing for Mr. Simon to object to. A hearing was never commenced from which the findings of fact and conclusions of law were used. The judge did what domestic relations courts do on a regular basis. They put counsel and the clients in the courtroom, they turn on the recorder and they talk about the case. And in reviewing that hearing in this case, that's exactly what happened. No one was told to call a witness. The court didn't ask for a court reporter. The court merely sat on the bench and directed how he thinks he wanted things to go. He states, we will get an entry on that. Somebody can accept or appeal or do whatever. But I want to get an entry on, resolve these questions, and then recuse myself from this case, be off of this. So send them the stuff. Both of you are going to give me a written argument. All I need is arguments from you. Make your best argument. They both submitted arguments. Nothing happened for 4 months. 4 months later, Mr. Ferguson goes in and files a set of findings of fact and conclusions of law that kicked this whole thing off. Yes, pro se litigants are held to a standard, but the Supreme Court has also indicated that there are instances where pro se litigants need relief. This was a complicated case. I believe I quote Mr. Lane accurately. it was complicated. If the court looks at the trial court docket, the person filing all the motions, the one craving a conclusion to this case, is the appellee. This is an instance where the trial court took the opportunity to adopt unfair, improper findings of fact and conclusions of law, make spousal support retroactive for 5 years from the date of the filing of the motion. Retroactive. Support is retroactive to the date of filing. I've never seen anybody go 5 years prior to the date of filing. This was authored by appellee's counsel. The judge adopted it. Judge Quinn didn't do what he needed to do. 60B5 is there to prohibit, to prevent litigants, particularly unskilled litigants, from this type of an outcome. And we would ask that the court send this matter back down and have the issue heard before Judge Hoffman, where you can anticipate that there will be an evidentiary hearing, and there will be testimony, and there will be exhibits. Mr. Simon is entitled to this court's relief, and he asks that the court grant it. Thank you.
Thank you both gentlemen for your arguments before the court today. As you know, the court will take the matter under advisement and will issue a written opinion which will be sent to the parties, as well as we release our opinions on our website. Mr.